Hi, and welcome to State Trustees webinar on online wills for turning your wishes into a will in as little as 30 minutes. I begin today by acknowledging the traditional custodians of the land on which we gather today and pay my respects to their elders, past, present, and emerging. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. Thank you all for joining us today. I'm Jessica, Product Specialist at State Trustees, and I'll be facilitating today's webinar. In my role, I identify ways to enhance the online will service so that it continues to offer value, peace of mind, and is accessible to all Victorians. Today, I'll be joined by May and Theory, who will now introduce themselves. May?
Thanks, Jess. Hi, I'm May. I'm one of the relationship managers at State Trustees. So I've been at State Trustees for just over a year now. So I work within the community to educate Victorians about the importance of having their financial and legal affairs in order, particularly their wills and financial enduring power of attorney.
Good afternoon, everyone. My name's Theo. I'm also a relationship manager at State Trustees. I've helped more than I've helped thousands of clients and employers over my 18 years here at State Trustees. I feel fortunate to work for a government-backed company that supports all Victorians. We provide care and expertise in managing their financial and legal matters when they need it. Currently, I educate the community about the importance of wills and enduring powers of attorney. I also enjoy providing choices and solutions to people.
Thanks, Theo. Thanks, mate. It's great to have you on board today and to have all of your expertise as well. I'll give everyone a little bit of an intro about State Trustees, in case you're not familiar. We're a government-backed company providing comprehensive legal and financial services to all Victorians. Since 1940, we've written over 250,000 wills and administer more deceased estates than any company in Victoria. We help you look after your financial and legal affairs in times of need and when you pass away. Our services include wills and power of attorney preparation, attorneyship and estate administration, trusts, charitable giving, and financial administration. In our webinar today, May and Theory will explore the key features of an online will, your other options, and what makes an online will a simple and legally valid way to secure your wishes. You'll have the opportunity throughout the webinar to ask your own questions in the chat, so please feel free to send them through. So we'll begin today by asking, what is a will and why an online will? Theo, can you answer this for us?
I certainly can, Jessica. So a will is a legal document specifying the distribution of your estate. In Australia, it must be in a written form and it excludes video and voice recordings. The key purpose of a will is to legally express your wishes for the distribution of your assets. Clear and precise writing is essential to ensure that your wishes are respected, and many individuals do choose online wills for the added convenience, as the process typically takes no more than 30 minutes and can be completed from the comfort of your own home.
Great. Thanks for that intro on wills for us. Now, who can actually write a will? Is it different between the states and territories in Australia?
Sure. Any person over the age of 18 can actually prepare and write a will as long as they have what we call testamentary capacity. So what is testamentary capacity? Testamentary capacity means that you are of sound mind, you understand what a will is and what a will does. And yes, every state does have different laws, and despite that these differences do exist from various states, it is reasonably fair to say that it's generally a will is recognised across all jurisdictions, but there are some little differences in terms of the law of the land, so to speak.
Of course. Great to know. Now, May, I might throw this next one to you. Why do you need a will? And what happens if you pass away without a will? I'm sure that probably complicates some things. So could you elaborate on that?
Yeah, sure. So there's many reasons why having a will is important before you pass away. So when you do pass away without one, you don't get to have a say in who benefits from your estate, as well as you don't get a say in who administers and makes final decisions about your estate. And because you're not leaving any instructions or wishes before you pass, it actually takes quite a long time to settle the estate as well. So sometimes it's going to be more than 12 months. And because of the added time that it's going to take to, whether it's done in court or outside of court, the cost to settle the estate can be significantly more as opposed to if you had written the will. So ultimately, every Australian should have a will, whether you're single, whether you don't have dependents, or you feel as though you've got few assets with simple circumstances. It may seem simple now, but once you do pass, it can be a bit more complicated than you might think.
Of course, and today's webinar is all about understanding why a will is important and why we need one. Well, before we get to that stage of having a will, what are some things that we should be considering? So what are some factors that you should have before writing a will?
Yeah, so the main one is what assets do you have? So it's good to just take stock of that. And amongst that, do you have any cherished items? So these can be things that have an intrinsic or personal or emotional value. They might have a story tied to them, so you might want to pass down that story as well. If you've got any minor dependents or children, who's going to be their guardians, and similarly for pets as well, who will look after them once you pass. One of the biggest things is who will be the executor. It is a big role to play. So it is really important that you consider what they need to do and who will be best suited to do that, whether it's an individual or an organisation like State Trustees. Also, who are going to be the beneficiaries that are going to have, your estate distributed to them? Are you passionate about any sort of charities? Would you like to leave something to them or make a bequest? And of course, once you pass, of course, you'll have your funeral. You can also leave the funeral instructions and wishes within your will as well. So it's a good idea just to think about those things as well, so that your family know what they want, what you wanted whilst, you were still here.
Of course, it seems like there's lots of things to consider before preparing your will. So thank you so much for shedding some light on those aspects there. Now, Theo, what are the benefits of choosing our online will service?
Well, there are three main benefits. First, it's easy, it's convenient, and you do it yourself. Let's look at easy. So you're creating an online will. It's straightforward, it's easy to follow, it's step-by-step tips, and the questions to complete online in accordance to your wishes. So it's pretty straightforward. You do it at your own pace. It's convenient. You do it online, you do it at your own pace, in your own time, in the comfort of your own home, and you don't have to schedule an appointment with a lawyer. And finally, doing it yourself means that by doing it yourself, there aren't any additional costs. It allows you to create a legally binding will without incurring those additional fees or costs associated with the preparation of a what we call a consultative will. Any additional charges, whether it's storage, whether it's travel, if you can't travel to a legal practitioner. So by doing it at home, online, at your own pace, it's a perfect solution. It's one of the solutions. It's a perfect one.
Yeah, great. So an online will sounds like it's kind of ticks all the boxes there, and it's just a nice, easy, convenient product for people that just want to create a simple, straightforward will. So
it is convenient. And could I just add that, with online wills that State Trustees does offer the general public, there's a step-by-step guide. It's robust. Whilst you do it at your own pace, you've got unlimited edits within 90 days. And the only time that edits aren't permissible is when the document itself is finalised. Now, the document is valid across Australia. And if you sort of strike a bit of a snag, you can always, call upon us. There is support that's available through State Trustees, and it's also backed by our legal experts here at State Trustees.
Amazing. Thank you so much for expanding upon that with the online will I think what we'll do now is we'll actually give people a bit of a look into of what the online will is and how the platform works. So we can show everyone the steps to registering and what happens when you've done that. So if you're confident in writing a will yourself and your circumstances are simple, our online will is a great option for you. Like Theo said, it does take as little as 30 minutes to complete online. And once you're done, you'll need to download and print it, have it signed by your witnesses, and then it'll be legally valid. It is important to mention up front, if you are completing an online will, we prefer that you use a desktop or laptop device over a tablet or mobile phone. It just has better user interface as well. So once you've registered and you're ready to start creating your online will, there'll be a range of sections for you to complete in. So the first part, or step one of the online will, is the personal details section. So in this section here, we want you to tell us everything about you. So everything about you to help set up your will, ensure that your personal information is correct and recorded as they appear on official government documents such as your passport. If you're married or you have a partner, you'll be asked to fill this in. There'll just be a little section below where you'll add your family details. And if you do say yes to having children under 18 or pets as well, that will open some future prompts later on in the will, but we don't need to worry about that right now. At the end of every stage, you'll fill in all the bits that you need to that have the little mandatory asterisks, and then you'll go save and next. And then the second part, so step two, is the executor section. Now, the executor section is who should manage your estate after you die. This is a very important aspect of the online will and something that you should consider quite seriously. Your executor will be responsible for carrying out the instructions in your will. So you can appoint a person here or a trustee company like State Trustees, and that this person or company will be responsible for ensuring your wishes are carried out as per your will. Now, you can pick one executor or two executors. So there's a sole executor option or a joint executor option as well as the options of appointing substitute executors for each option. So lots of considerations there. And when you do pick an executor, we do recommend that you have a chat to them beforehand, just so that person knows as well that you've picked them as the executor in your will. Once you've completed this section, you'll go to step 3, which is the guardianship section. Now, this is care for your children. You'll only need to complete this section if you said that you had children under the age of 18, which was in step 1, the personal details section of the online will. Here, you can name a guardian and they'll take care of your children in the event of your demise. You also have the option of appointing a substitute guardian as well, should your primary choice not be there for whatever reason. It's important to note that the guardian that you appoint here is not your partner, as the guardian appointed will only take effect if your child or children's other parent pass before they turn 18. The next section is step 4, pets. We know that a lot of people these days are including their pets in their will. I know I'm including my pet in my will that I got throughout COVID. I definitely want them to be looked after. So it's important here that you can pick and choose between options of how you would like your pet to be looked after. So for instance, if you want someone that you trust to look after your pet, you can nominate them as a carer. And you also have the option here of leaving a gift of money so that person can use it to look after your pet as well. It's important to note that this choice or nomination is not legally binding. Having it in your will means that everyone will know what you wanted for your pet. So again, it's important to let your carer know that you've picked them and get their consent as well. And this will also be a conversation to have a chance to talk through how your pet is to be cared for should you pass. After this section, we go to step 5, which is funeral service. So under the funeral services here, we ask how you'd like to be celebrated. Again, talk to your executor and your family in your lifetime about what you would like for your funeral wishes. For instance, if you have any specific funeral or burial arrangements that you wish to be followed, you may want specific funeral arrangements outlined, such as I want everyone to wear purple on the day, or I want a specific song to be played throughout the event. So if you do have specific wishes like that, what we recommend is including these on a separate page and paperclip it, not staple it, to your final will and share this with your executor as well. Don't forget that you can always come back and edit any sections of this will at any stage, as long as it hasn't been finalized first. After this section, we go to step 6, which is the residuary estate. This is also another very important part of the online will, and it's who do you want your estate to go to? So in here, your residuary estate covers everything you own, from your property to your bank accounts, your shares, and your personal belongings. It does not include specific gifts. There is an entirely new section for that, which we'll talk about right after this. But basically here, you have the option to leave everything to one person, such as your partner, or you can divide your estate between multiple people and a charity of your choosing as well. If you are picking a charity, what we do recommend is you use the Australian Charities Not-for-Profit Commission, the ACNC, just to make sure you've got the correct ABN for that charity, and you can link it up as well, just to make sure that everything is correct and accurate in your will. Following from this, step 7 is gifts. So here you can leave special gifts to people that are the most important to you. A gift can be a possession, money, or both of those options. So what we do recommend as well is, if you have a large quantity of gifts and you think that that list may change from time to time, you can again attach a piece of paper to your online will with an itemized list of all the gifts that you want. And what you can do in this section as well, some people may not have gifts. You may want to skip this section, or obviously leave some gifts. When you allocate a beneficiary a gift, you also have the option of adding a subsequent beneficiary as well, should that person not be around when you pass away. So for instance, here you might go, I'm going to add a new beneficiary, and I'm going to allocate them my car. So I'll allocate my car to my daughter. But if my daughter's not around, I want the subsequent beneficiary to be my cousin. So that's just how the gift section works there. And then the final portion of the online will, or step 8, I should say, is the minor beneficiaries section. Now, it's important to know that this section is not just pertaining to your children in the will. If you have children, it's for any person or any beneficiary in the will that may be under the age of 18. And basically speaking, beneficiaries under the age of 18 can't receive their gift or share of your estate straight away. So they need to actually wait till they're 18 years or the age specified in the will. Despite any age restriction included in your will, your executor does have the power to advance money for education, care, and general well-being of a minor beneficiary. In the online will option here, you can select anywhere from between age 18 all the way to 30. And so once you've completed all of those steps of the online will, you'll be able to review all the sections. Again, you can edit these at any stage within that 90-day period as well, just to make sure you've had those chats with the people that you need to and confirmed everything you need and haven't forgot anything. Once you're happy with it, you can review your will and have a read of it. You'll then be ready to finalize it. And once you finalize it, you'll receive a download of the will, including an email with the will and some signing instructions on how to witness and sign it. It's very important that you follow those down to the T's to make sure that your will is legally valid. Please note, electronic signatures are not accepted, so please print off your will before signing and witnessing. Now, we understand that online wills may not be suitable to everyone, and that's why we also offer a consultative will option as well. So with our online wills, and Theo, you touched on this a little bit earlier as well, the accessibility, they're straightforward for easy estates and uncomplicated wishes, and they're also cost effective. So they're a more affordable DIY option without any additional legal fees. And they're also incredibly time saving. So they're convenient for those with time constraints who may live very far away from our Footscray and Dandenong offices. And you can complete these at your own pace as well in your own home. So comfort is key there. With our consultative wills, these cover complex estates. So they're beneficial for intricate estates, extensive assets, or complex family situations and blended families as well. We give personalized advice, so they're ideal for tailored advice and guidance from legal experts board trustees. We have legal expertise as well, so suitable for those who are wanting professional legal assistance in the will creation process, and also for estate planning, so helpful for comprehensive estate planning and addressing potential beneficiary disputes. It's important to note up top to assess individual circumstances to determine the most suitable option for you, so whether it's an online will or a consultative will provided by estate trustees. And you can view all this on our website as well for a comprehensive list of all the details. If you're still not sure if it's right for you, we have a team of will writers available in our Footscray and Dandenong office who are happy to meet with you and prepare your will. With our online will, I just want to note that everyone's circumstances are different. Because it is designed for simple, straightforward circumstances, it doesn't cater for multiple properties, so properties that are excluding your principal place of residence, for investments, self-managed super funds, blended family circumstances, trusts, joint wills or mirroring wills, and also bequests for special needs or disabilities. So if any of these apply to you, don't worry, a consultative will appointment with our professional will writers might be a more suitable choice. You can book in an in-person appointment at Footscray or Dandenong, and I'm pretty sure there'll be a link in the chat as well, and you can view that and you can book at your own convenience. So thank you everyone for having a look at that online will in-depth explanation with me. We're going to jump on to some more questions now. Theo, after all of that talk, is the online will legally valid?
Absolutely. So online will is legally valid. You can make a simple, legally valid will with state trustees, or the online will with state trustees. There are many formats that can be used to create a legally valid will, as long as the requirements of validity are met. As you mentioned earlier, Jess, online wills are not for everybody, and it all depends on their circumstances and the complexity of their assets. So when in doubt, reach out, ask the question, and it could well mean that you may need to have a meeting with one of our will writers based on the complexity of your financial affairs.
Yeah, I agree. And I think it's important to note that, you know, we've got our contact center. People can call us if they're not sure about which product is suitable for them as well. You know, we're always really friendly and happy to have a chat and help navigate you to which product might be suitable for your needs. So that's something for people to keep in mind. I know we commonly also get asked, how do I update or change my online will? I know circumstances change all the time. You know, it might be a life event or change an address. So are you able to expand on that a little bit, please, Theo?
Sure, absolutely. So you've prepared a will, your circumstances have changed a little way down the track. You need to prepare a new one. By preparing a new one, you can do an online will because you're adding or you're deducting the information that appears in your will to reflect your current circumstances. It's the same when you consult our will writers. If your circumstances change and your will needs to be altered, again, you'll need a new will prepared for you. What we say is that you regularly review your will. And when we say regularly, anything between 3 to 5 years, have a look at it, ask yourself the question of, does my will reflect my current circumstances? If it does, there's no need to change it. If, however, the answer is it doesn't reflect my current circumstances, that's the trigger to look at updating your will, whether it's your online will or whether it's a consultative will with a will writer at State Trustees.
Perfect. That's really helpful to know. So 3 to 5 years is kind of sort of your key, like a reminder. I might put that in my calendar
Pretty
just to
much.
sort of pop up and go, okay, has anything changed? What do I
Absolutely.
need to do? You know, sometimes life gets in the way, and before you know it, everything's sort of changed in your landscape. So always important to have that updated to reflect your wishes. Now, May, I'm going to throw this one to you. Does an online will need to be registered? What does that mean?
Sure. Well, the short answer is no. The will doesn't have to be registered, but some people do choose to register their will for safekeeping. So in Australia, there's no legal requirement that exists to register a will, whether you do it online or whether it's a traditional consultative will. So although registration is not mandatory for legal validity, compliance with each state or territory's legislation is the key component there. So to make sure that the will itself is valid, the Wills Act does require the will to be a written document. It does need to be signed by 2 witnesses at the same place, at the same time, with the same pen, with the intention of it being a will. There's no specific wording or format that's been mandated as well. So it is just write it the way that you'd like to. There are samples and things online that you can see as guides, but if you do need more guidance and you'd like to speak to one of our will writers, you can always give state trustees a call. They can help address any concerns that you do have as well.
Amazing. And I do know that the online will, once you finalize it, it actually comes with a signing instructions PDF as well, and it tells you how to sign it and who can sign it, and if you're using the same pen as well. That's something that is, you know, I would have never thought of until I learned that myself. So it's always just those helpful little tidbits to help to get you on the way. Now, we've talked all about the lead up to the online will and completing an online will, but what happens once it's finished? Well, what are the next steps there?
Yeah, so this is the part where you will decide where you're going to store your will. So this can be done at home if you'd like. But what a lot of Victorians can do is use the Victorian Will and Powers of Attorney Registry, which State Trustees offer. So it's a free registration and storage service, and the process is really easy. So you either send in your original documents if you'd like us to store it, or if you're keeping it at home or at the bank, you can register the location of them as well. So all you do is you fill in the form on the website, and then what you need to do after that, you'll be prompted with.
Amazing. So just to reiterate, there's a will bank and a will registry. So one service I can actually send my completed will in for state trustees to keep safe, and that's for free for Victorians. But also the will registry, I can tell them where my will is and ask them to just keep note of that as well, correct?
Correct.
Oh, I love that. That's such a great idea. Well, that covers through the online will now. We're going to go through some questions that are frequently asked about wills and our online will as well. So the first question is, how long is my online will account valid for? Theo, I think we touched on this before, but could you please elaborate?
Sure. So as I said earlier, your online will account is valid for a period of 90 days or 3 months. If you complete it, if and when you do complete it, you no longer have access to that online will. So you've got 90 days, you complete it. As I said earlier, you can do it at the comfort of your own home, at your own pace, at your leisure, within that 90-day period. Once you finalised it, it locks it, and you no longer are able to make any further edits to it.
Yeah, no, thank you for that. Great for clarifying. And how much is it for the online will? How much is it for a single? What about a couple? Theo?
Okay, so our online wills usually are $69. I believe there's a discount that will come up in the chat of about 59, I believe, and I think that's valid till the 15th of this month. By law, each person needs to have their own will, own individual will. So in a couple situation, one will does not actually cover 2 individuals. Each individual needs to have their own will, and each person can complete it. They can mirror one another. However, they are 2 separate documents.
Yes, thank you for clarifying, because yeah, it's not just mum and dad want a will, it's each person needs their own will.
Correct.
And you can still do that with the online will. It's just making sure that you complete them the same as each other. And I guess that price as well, about how much it costs for the online will, that's the same as when you're updating a will as well, because you're creating a new will. So if you're updating a will 2 years down the track, it will still be the price of what the online will is.
Correct.
Amazing. Great. Thank you for that. Now, what about the security of the online will, May? Is it a secure and safe platform?
Yeah, absolutely. It is definitely secure. So state trustees is a well-established organisation, and we do have enterprise-grade multi-layered security that not only protects information now, but it also protects well into the future as well. So all the information that you enter into an online will is encrypted. And so that means that we can't view your data or your personal choices. And in addition, your will can't be edited as well. And we also do have dedicated in-house teams who monitor our systems against any potential threats and additional lines of defense as well.
Great. So good to know that all my personal private information that I'm uploading into this platform can't be viewed or seen by anyone else. So it's very safe and secure. Perfect. Now, another common question we have is, what if I'm young and I don't have a lot of assets? Surely I don't need a will, but I think that would be quite a different case. May?
Yes, great question. And yes, absolutely. Even if you're young and you feel as though you don't have any substantial assets, it is still really important to have a will. So the main one is that the will does allow you to make decisions about who receives your possessions or your assets, irrespective of their value. So like we talked about before, you may have sentimental items, and these are sometimes priceless. And for some people, prices can have different meanings. So you might have an Xbox, you might have something that's been passed down for generations, your mobile phone, which we're all glued to. They're all, they're all assets that you can include in your will. So even if you don't feel like you have much, you can start thinking about this. Just look around your bedroom, your car, even your bank accounts. You might have specific items that you'd like to include, and they might be left to certain individuals as well. And that means that whilst you're still here and you can write the will, you can write it in, you can have your instructions and your wishes in place so that whoever you want to have receive that can receive it. And also another important thing is about any minor dependents or children that you might have. If you do have them, the will does allow you to appoint a guardian to take care of them. And this is really crucial despite, having your assets in your will as well. And something you touched on before, Jess, having a fur baby during COVID, that was quite popular. That was something that a lot of people did do. And then there might be family pets or just any animals that you might have. They can also be included in the will as well, just in case something does happen to you. Someone is aware of what you would like to have happen to them and who you'd like for them to be taken care of by.
Yeah.
And one of the main things as well is in terms of avoiding potential disputes. So having the will in place just means that family members do understand what your wishes were. So that can avoid disputes, and it provides a bit of clarity and guidance as to what you wanted to happen. So it does prevent some conflict.
Amazing. I guess you don't realize how many things you actually have in your possession or things that you want taken care of until you start actually thinking about it that way. So yeah, definitely some things to consider there. You're never too young to have your will prepared. So that's fantastic. Now, we mentioned this term quite a lot through the webinar, and some people maybe want a bit more of an explanation on it. Theo, what is a beneficiary?
Okay. A beneficiary, Jess, can take various forms. It can be an individual person, could be an entity, could be an organisation. All of them are destined to receive assets, funds or benefits from a will, from a trust, policy insurance, or any financial arrangement upon the death of the testator or the benefactor. The intended recipients will receive, depending on how the will is structured, how, what assets are bequeathed, they're actually outlined in the document, and they will receive whatever is coming their way, I guess, at the death of the benefactor.
Great, thank you for clarifying that. And another thing I would like you to please clarify is, can you explain the difference between a legal representative and an executor?
Sure. So a legal personal representative is a term for either an executor or an administrator of an estate. If there is a will, there's a grant that's granted from the probate's office, and it appoints appoints the appointment of an executor. It's 2 appoints in a row, but yeah, if you get my drift. If there is no will, then letters of administration are sought through the Supreme Court, and then it's a personal representative or an administrator of an estate that is given the role and the responsibility of administering that estate. But whether it's an executor or an administrator, they may be referred to as the legal personal representative of the estate.
Okay, good to know. Good to know. I think that's one that I've definitely been confused on in the past. So
Sure.
I'm glad that, you've got so much experience around this area as well. So I'm glad to hear you say that. Another term that we kind of get people sort of questioning about is residuary estate and what it is and what it entails. Am I able to get you to answer that one, please?
Yeah, sure. So the residuary estate refers to the remaining assets and property within the estate. So that's all the things after any special gifts, bequests, debts, taxes, administrative expenses have all been addressed and distributed according to the terms of the will of the trust. So in essence, it includes any assets or property that weren't explicitly designated to any specific individuals or entities as part of the will or trust, and they don't have any special instructions tied to them. So the residuary estate is distributed amongst the residuary beneficiaries, who are typically named in the will to receive the remaining portion of the estate.
Perfect. And I know that in the online will, we had the residuary estate section as well, and you can nominate a person or a charity there and sort of divide your estate according to your wishes. So you could do in equal shares or percentages like that as well. So lots of options there around residuary estate. Now, another question that we're getting, and I can see a few people have asked for it as well, is what nullifies my will? So what are ways that it can be revoked? What happens if I remarry? Is that a way that it could be nullified? What happens in this situation?
Sure. So wills can be revoked in many different ways. So with marriage, unless the will is made in contemplation of marriage, it does get revoked. But I do want to say that although marriage revokes the will, a divorce doesn't. So in the case of a divorce, we put a line through the divorced spouse and treat the spouse as though they've predeceased, unless there's a contrary intention in the will. Other ways that it can be revoked is by making a later will with a later date, by stating in writing where you sign and have it witnessed to say that you'd like to revoke the will, and also by destroying the will. So this can be whether you rip it up, whether you write on the will, you light it on fire, you throw it in the water, or even if someone steals it, it does become revoked.
Interesting. I love the creative ways to destroy a will there, so you can have a little bit of fun with it. So that's nice to know. Another question that we've got here is, what's the role of an executor and who should you appoint? I feel like this is a very important question. There's lots of factors behind it. So Theo, your thoughts on this one, please?
So the role of an executor, it's an important role. And one must choose wisely. And why must they choose wisely? For a number of reasons. One, they're prepared, they're willing, they're able, and they're around. Now, when you've identified your executor, their first job is to locate the original will and then arrange the funeral. It is the executor's responsibility to then administer the deceased person's estate, and that includes the deceased person's assets and their liabilities. So whilst many people consider becoming an executor quite an honour, it does have its roles and responsibilities and stresses, and has some pretty interesting moments, especially when you're dealing with beneficiaries. And the beneficiaries take various forms. What are your options? An individual, another trustee company, or state trustees. Why? because we're the experts in the field, we're independent, we're impartial, been doing it for over 80 years, and we've administered in excess of 30,000 estates since we began operation in Victoria. So, and we have the wealth of experience, we have the manpower, we've got the resources, and the other thing is that we take on the liability, and that's the important bit. So when you're appointing an executor, make sure you're appointing the appropriate person or organisation. Another thing I'd like to add here, Jess, is that when you are making an appointment of an executor, it is also wise to insert a substitute executor. By inserting a substitute executor means that if your primary executor has passed away or predeceased you, wishes not to take on the role, or is medically deemed to no longer have capacity, it then defaults to your substitute executor. If you don't have a substitute executor, then obviously the law instructs that an executor needs to be appointed, and the court will actually do that to find the most appropriate executor. So when you're preparing your will, whether it's online, whether it's consultative, you make sure that you put your primary executor and you also include a substitute executor. Very important.
Amazing. That's a great point to add. I do know on that area that our online will actually asks you to appoint a substitute executor. It's a compulsory field, because having that fail-safe there is very crucial. So thank you so much for expanding on that point as well. And now we've got some common mistakes that people make when writing a will. I mean, I feel like there's so many things to follow, so many instructions, that it's easy to sort of forget a few things. So what do you typically find are some common mistakes to avoid when writing your will?
The main one is not having a will to start off with. Yeah.
Yeah.
Because your wishes and desires aren't listed. All jokes aside, yeah, that is the main one. Yeah. So I guess the second one is not appointing an executor, as I said earlier, who's willing to act, not including all your assets, forgetting your liabilities, excluding certain people who may be financially dependent, with the actual physical document itself, not having all parties, and when I say all parties, witnesses present on the day, not using the same pen as May said earlier in this webinar. That they're common mistakes. We see wills where, there's a black pen that's been used, there's a green pen, there's a red pen. That only indicates to us as experts in the field that not all parties were present at the time when the will was being executed or witnessed. Not storing your will. So they're the common mistakes, and the big ticket mistakes, I would say. Okay. Again, another mistake is if you do choose an online will, it may not cater for your complex, affairs or circumstances. That's important, because it's not the online will cater for those individuals with less complex, asset structures or their circumstances. So, when in doubt, check out both and work out what's best for you. And if you're still stumped, just give us a buzz, and we'd be more than happy to direct you to the most appropriate product.
Of course, peace of mind is key here, so feel free to ask any questions you have. Now, one final question we have, that's all we have time for, is if state trustees act as executor, are there standard charges, or does it depend upon the estate size? May, can you shed some light on that, please?
Yeah, sure. So State Trustees does charge fees as they are outlined on our website. So the main charges are capped at 5.5% of the estate. There are additional charges for things like conveyancing, tax, genealogy, and disbursements as well. However, one thing to keep in mind is that trustee companies do differ from solicitors in that trustee companies like State Trustees handle the entire estate process. So they'll provide end-to-end service, so from funeral involvement to asset management, grant acquisition, property handling, conveyancing, tax work, and beneficiary identification. And not only that, State Trustees also assumes personal liability. So it relieves the executor or family members of responsibility. And clients that are willing to pay for professional services, it does help them to alleviate the burden and risk for the family as well.
Great. Thank you so much for that, May. I'm pretty sure we've popped some information in the chat there about our fees and pricing as well. I am mindful of time. We have come to an end of our webinar now. I just want to say thank you to everyone who attended and to our wonderful hosts. Today, we looked into the essential aspects of an online will, when it's worth considering alternatives, and why online wills offer a straightforward and legally sound method to protect your wishes. Again, Theo, May, you are both wonderful. Thank you for your expertise and all the knowledge that you've given us today. To all our attendees, if we didn't get to your question, please contact us directly. The link to the chat, to the contact information, can be found in the chat. We all hope that you are now ready to take the next steps on your will journey with us, whether it's an online will or an appointment with one of our professional will writers for more complex matters. We have a range of options and experts to help. Please visit us at statetrustees.com.au/wills to get started. Thank you everyone for attending.